be generic, but specifically for the civil unrest, it covered the broad array of the different types of crimes.
Now, talking about the different types of crime, were you, as national coordinator during the unrest period, were you receiving information, crime statistics reported in the different areas, and are you able to provide us with such?
Well, I can place on record that yes, as the national coordinator for the Hawks, that we were being given an hourly report of all reported cases throughout the country. So every hour of the 24 hours, we were able to update our statistics, and that needed that intervention to put in place combat strategies, prevention strategies, and investigative strategies. My Lord, yes, I am in a position for KZN to give a complete breakdown for those 7 days of the 11 districts, policing districts into which KZN is broken, the number of cases that came in for those 7 days, and the stations that was affected by the civil unrest.
You have recorded the same in your statement to the police, correct?
That's correct, my Lord.
It's in paragraph 15.1.
That's correct, my Lord. Paragraph 15.1 on page 5.
Can you please take us through the numbers, as it were, of what the reported crime was and what the country, or the shape of the country was in that period, as far as unrest and violence is concerned?
My Lord, the 11 districts, I'll start the first. The first district is Amajuba district. There were 62 reported cases with 15 arrests that constituted malicious damage to property, possession of stolen property, and arson. The affected stations was Madadini, Ozudwini, and Newcastle. The second district is referred to as the Itugela district. It had 5 reported cases with 3 arrests that constituted possession of stolen property, and the affected stations were Izekeli and Ladysmith. The third district was Lobo district. The district had 51 reported cases with 3 arrests that constituted malicious damage to property, murder, arson, and the affected stations were Pietermaritzburg, Howick, and Alexander Road. The fourth King Chetwayo district, the district had 63 reported cases with 15 arrests that constituted malicious damage to property, possession of stolen property, and arson. The affected stations were Impangeni, Malmut, and Izikeleni. The next district was Itigweni district. This district had the most. It had 383 cases with 41 arrests that constituted malicious damage to property, possession of stolen property, and arson. Affected stations were Durban Central, Isipingo, and Verulam. The next district is Ugu district that had 37 reported cases with 24 arrests that constituted malicious damage to property, possession of stolen property, and arson. And the affected stations were Amzinto, Potchefstroom, and Izigolweni. The next district is Mzanyati district. The district had 17 cases with 6 arrests that constituted malicious damage to property and possession of stolen property. The affected station was Greytown, Helpmekar, and Msinga. The next district is Ilembe district that had 30 reported cases with 6 arrests that constituted malicious damage to property, possession of stolen property, and arson. And the affected stations were Kwadakuza, Inyoni, and Surumbeli. The next district is the Harry Gwala district that had 9 reported cases with 7 arrests that constituted possession of stolen property. The affected stations were Ikopo, High Flat, Donnybrook, and Bulwer. My Lord, the next district, I might not pronounce it right, Umkanye Kude district. The district had 12 reported cases with 3 arrests for malicious damage to property, possession of stolen property. Effective stations were Jozini, Ngwavuma, and Imanguzi. And the last district was Zululand district. The district had 5 reported cases with 4 arrests that constituted of attempted murder, possession of stolen property. Effective station was Magudu and Babanango. My Lord, that's in respect of the KwaZulu-Natal leg of the civil unrest.
Now, I just wanted to comment, given those statistics, what the situation in the KwaZulu-Natal province was during that July 21 unrest period.
My Lord, if KwaZulu-Natal and Gauteng, the 2 most affected stations, provinces, what became evident that the civil unrest in KwaZulu-Natal was just not of criminal basis, but it was a violent, as compared to Gauteng. The activities of the protesters and looters were very, very violent in KZN, as opposed to Gauteng, where, yes, they did loot, they did steal, but we see the majority of the violent crimes, whether the murders or attempted murders, resulting from the civil unrest, emanates from KZN. So there was a sense of the violence in KZN as opposed to Gauteng. In terms of quantifying the value, Gauteng did indeed have a much higher value because some of the malls that were there lost billions of rands in losses. So to quantify in terms of rands and census, Gauteng did suffer a big loss in terms of rands and census, my Lord.
Any further investigations or any further methods that you use that you would like to place on the point?
My Lord, I would refer to the Twitter side of the investigation, which I refer to WhatsApp, the Twitter side of investigation. And I think just to place it on record, there will be a cyber forensic expert that will be coming to testify. But when we're dealing with Twitter, Twitter is formatted in such a way that you get a Twitter handle that is referred to as a name and a Twitter ID, and that is generated by the holders of the Twitter license. That Twitter ID gives you numbers in different digits. Some is 7 digits, some is 14 digits. So we got a Twitter handle, a name of a person, and a Twitter ID, where we are able to identify a person by the handle and a person by the ID. And my Lord, the reason why I'm placing this in perspective for the court is that we would see that when we did the Twitter investigation, it became evident, more specifically with the accused that's before court, that we picked up 3 Twitter handles with the same or similar names. And if the court allows me to refer to paragraph 20.
General Governor, you may do so, but very, very superficially, because the expert herself is going to come to testify on that. Right? Just go through it superficially.
That's correct, my Lord. My Lord, on.
But it is important that we fully understand the issue of Twitter and
If my Lord,
one who specifies.
yeah, it's fine, I can allow him to do that. Okay, go ahead.
Thank you, my Lord.
You mentioned Twitter and I. Can you expand on that?
My Lord, when somebody wants to use Twitter, they will register. And then you can register under your name, you can register under a pseudo name, or you can register under prefix.
Its name simply means that it's registered under your name.
That's right, under your name. And then as a result of that registration, Twitter will send a Twitter ID, meaning that they have recorded that that ID number has now been issued to that specific person with that specific name. My Lord, as I indicated on paragraph 20, I will very superficially, for the court purposes, the 3 Twitter handles with the same or similar name of the accused before court. And I think it will be important that I place it in perspective that the first Twitter with an ID number 534-657-103 was created under the name at DZ Sambudla. And for record purposes, my Lord, we have established that this is a fake Twitter ID.
Explain to the court what a fake Twitter ID is.
Sorry, my Lord.
Explain what a fake Twitter ID is.
My Lord, a fake Twitter ID is where somebody else can create a Twitter account under DZ Sambudla. And through our investigation, it became clear and apparent that it wasn't being used, or the content was not that of the accused before court. It was a fake account that was used for their other purposes. My Lord, the second Twitter had a Twitter ID number. It's a long digit. It's 126-393-969-233-830-7073. That is the ID. And this was created at Zuma Sambudla. Now, under Sambudla, an N was added to make it Sambudla. My Lord, also for record purposes, we can say that that was also a fake Twitter that was created and not used by the accused before court. This was established once again through the content or the posting and the timing of some of the events that was picked up on those accounts. My Lord, the third one, with the Twitter ID number 114-125-954-230-462-4641. This was created under at Zuma Sambudla, and this is indeed the true and correct Twitter account of the accused before court.
Proceed.
My Lord, as a result of us interrogating the third and the original, and it became evident that through our investigative methodology that this Twitter account that was registered under the name of the accused before court was indeed being used for the purposes of conveying or inciting followers on the Twitter platform. My Lord, it's important that I also say the following, that a supporter and a follower are two different persons. We were able to see the followers on the Twitter platform. We were not able to say whether these followers are the supporters of the accused before court, but what we can say that these were followers on their Twitter account. When something was posted, there was responses by the followers. My Lord, as a result of the incarceration or the Constitutional Court judgment on the 29th of June, which we see was the start of the rise and fight in the country. And the reason why we say on the 29th, on the 30th of June at 09:57, the accused before court posted on her Twitter account, which reads as follows. My Lord, pardon me if I pronounce wrong. It says, Makaban, Izikati Sukurwa, Kulinkudla, Ngomakala, Ikukweni, Sipelile, Amandla. It's on page 7, paragraph 24. And if it's loosely translated in English, it means, comrades, the time to fight in this arena with the mobile phone is over. Subsequent to this posting, there were many respondents, followers that responded. And some of them have openly responded positively, and others have openly responded, accusing the accused before court of inciting violence and asked it to stop. And to qualify what I'm saying, my Lord, on paragraph 25, there was a follower who on the 30th of June, the same day, responded to the accused before court, and that follower had the name on paragraph 25 as I Think Boss at Zonda Izinja. And responded as follows. It continues on page 8, my Lord, on the top, where it said, I thought that you were mature. Stop inciting violence. Stop playing with the lives of the have-nots. The people marching are hungry. Your father gave them nothing. If they get injured or arrested, he still won't help them. Grow up, please. My Lord, as a result of this Twitter, it became even more clear. On paragraph 26 on the 8th, we could see the different inflammatory messages that was posted on the Twitter account of the accused. On the 8th of July, that's immediately on the midnight of the 7th, our Honorable former Minister, President handed himself over, but on the 8th, she posted on paragraph 27, another insightful message where it says, Cadres, you have not failed at President J.G. Zuma, open brackets, at my ANC, as close brackets. It says, but you will fail him if the fight for the radical economic transformation stops. You will fail him if the fight for the economic freedom stops. So our struggle continues from the outside, and we must intensify Amandla. Now, my Lord, of specific that caught the attention of the investigation team was the last 6 or 7 words. So our struggle continues from the outside, and we must intensify. And the interpretation from the outside, we knew our former president was inside escort prison, but outside, it means that everyone who's outside.
General Lalmi, can you hold a second? Lord, I have just been advised that it is 11:16. We are cut into hot staff short journey. It's 11:16 now.
For 15 or 30 minutes.
15 minutes. For suitable to me, I don't know about the hot staff is paying.
So everybody is comfortable with 15 minutes.
Escort is.
Very comfortable, 25 to
Escort is.
quarter of an hour.
I just want a point of clarity. In paragraph 28, you have the dates 9th and 10th of June 2021. And in paragraph 27, you refer to a date 8th of July. So can we just get some clarity as to which of those two dates, because you seem to be going sequentially?
Lord, yes, I want to humbly apologize. There was a typographical error. It shouldn't be 9th or 10th of July 2021, and not 9th and 10th of June 2021.
You amend your statement accordingly.
Yes, I will. Lord,
Proceed.
Lord, on paragraph 29, on the 10th of July, she posted a video of the late Mr. Chris Ali with the following importance. Open quote, "We shall attack these officers, even in the bedroom, even in the kitchen," close quote. Their followers subsequently responded negatively against her. On paragraph 30, on the same day, one of her followers by the name of Tabang 11, alias Tabang Malema V, responded as follows. Open quote, "Inciting violence while you sit at the comfort of your home," close quote. Now, my Lord, earlier part I mentioned the separation between a follower and a supporter. And this became clear that this Tabang Malema was a follower. He responded to a tweet, meaning that he'd been following her. There is other previous communication, but this was specific when he responded in a negative to her comments on paragraph 29. But Lord, as a result of this Twitter investigation, what became clear and evident that the accused before court, we know she's a very prominent somebody, she's the daughter of the former president, and she had a very big fellowship on the Twitter platform. And this qualifies her to be what we categorize as a social influencer. She's able to influence because of the number of followers that she's able to get across. But Lord, as a result of this social interaction, it is clear to the earlier question that it's able to reach out on the Twitter platform. Now we know Twitter might not be as big as WhatsApp in the billions, but Twitter has an equally big platform nationally and internationally. So of that 128 or 124,000 followers that she had, any message will reach out to that number of people immediately. But
Now, so that is your investigation as far as this matter is concerned, correct?
that's correct, my Lord.
Now, I just want you to focus on paragraph 10, which we dealt with earlier. I want you to describe to the court in clear terms what is a person of interest.
My Lord, we categorize persons of interest is when we did the analytical side of from a WhatsApp perspective, where a person of interest would be somebody who would say, take the 5 liters of petrol, or make sure it's raised to the ground. Their comments versus their position. Now, as I indicated, my Lord, we were able to take cell phone numbers and get the RICA information and identify people who they were through RICA. There was two types. RICA is where the cell phone was registered to the name, but we also picked up quite a number of cell phones that was un-RICA. But through the interrogation of the analytics and metadata, we were able to identify. So persons of interest are people of influence, either politicians, either ward councillors, either community leaders, or people, business people who are providing finances. And it became clear on these groups. My Lord, as a result of the information, it became clear that there was a business funding model in place as well. And out of the groups that we mentioned, my Lord, currently we have 64 accused appearing as a result of the arrest across this that's still appearing in the High Court of KZN that's currently pending. So a person of influence, we did not take the looters or the runners. We looked at people that could influence, people that could give, that was giving direction or financing this civil unrest.
Did you play any other role in any of the other investigations in this matter, in the unrest matters?
My Lord, yes, I did. Many of the operations, the arresting of the persons of interest of specific is the one that I just testified 2 weeks ago, where Mr. Bomkosi Kanyila was arrested by myself.
Perhaps let's focus on what is before us in this court. Let's not talk about something that is not before us.
My Lord, this part of the evidence, I understand at this stage.
The issue of people who were arrested, who are again in a court, has got nothing to do with this court. So let us focus on what is before us. So once you start mentioning other people,
My Lord, it will become apparent as we proceed why this particular arrest is of importance in this matter. If it can just be, it's just two questions that I have. I don't need to go into the detail.
all what I was highlighting to you is that if we proceed mentioning other people that were arrested somewhere else, that might divert what we're doing here. We may proceed on, I think your question was what is the person of interest? So you are still unpicking on that.
Yes, I appreciate that.
So you can just proceed.
So is there anything else you want to place in the part of this one?
Well, it's safe for me to conclude that, to say, as a result of the final investigation, it became clear that the civil unrest resulted in mass destruction of property and loss of lives. And the influence of the social media platform has played a critical role in the communication strategies that was used on the various platforms. And that impact was seen on the ground. Thank you, Lord.
I have no further questions.
Thank you, Mr. Kandai.
Thank you, my Lord. Good morning, General.
Good morning, Council.
Yes. You described yourself as the national coordinator of the investigation, correct?
That's correct. And appointed national coordinator.
Right. And thanks for giving us the kind of general background. But really, if I can divide your evidence into two parts, the first one was dealing just with generalities, and then towards the end, you dealt with the accused before us, correct?
Well, yes, sir, it was in those two phases.
Yes.
But the content was specific in terms of not generalization.
Yeah, well, but surely when you're telling us about supermarkets and all that, that was just general information. It has nothing to do with the accused, correct?
That's correct, Lord.
Yes.
I'll give you the overview. That's
Yes.
correct.
So yeah, so that's really, I just wanted, so that we don't waste time. I don't want to talk about all those generalities. I'm going to be talking about the case before this court. You understand?
That's correct,
Yes.
my lord.
And not that I don't appreciate the importance of, painting the broad picture. We thank you for that. But as far as the business of the day is concerned, we will talk about the accused person.
Thank you.
Understood? Yeah. Would it be fair, just so that we save time, to summarize what you call the first part of your evidence as follows? There was unrest in July 2021. It was more than the usual unrest, and it resulted in some violence. It was concentrated in Gauteng and KZN. Correct?
Correct, my lord.
Yes. Okay. No, fine. Now, as far as this case is concerned, you have not been involved directly.
Yes, my lord, I have been of all these civil unrest investigations,
Countrywide.
countrywide.
Right. But this particular case, the investigating officer is Colonel Nazo, correct?
Colonel Nazo is the docket carrier, yes.
And have you had consultations with him?
Yes, my lord.
How many?
Many,
Many.
with his commander and the chief.
Correct. And therefore you are familiar with his statements.
No, my lord, I have not seen his statement.
Yep.
I'm aware of the content of what I spoke about, but his physical statement, I had no insight or bearing.
So you came here to testify without having had insight into the evidence of the investigating officer, the person in charge of the investigation into this particular accused.
My lord, I think it's safe to say, as the national coordinator of all the investigation, this specific case, I'm very much aware there's been engagements with the investigation team of KZN, the commander, the National Prosecuting Authority. But I did not inspect the docket physically like his direct commander, General Sonona, who would have done that. Mine was the overview of procuring the evidence and presenting facts and factual aspects to it.
Yes. No, I understand that, General. Believe me. All I'm saying is that, as you have just said now, you are 5 steps removed from this case. So there's you, the national coordinator, and then there's various people until we get to the IO, to the investigating officer. And you have not familiarized yourself with the actual investigation into this specific case. It's not a criticism, I'm just establishing the fact.
My lord, that will be correct. From a national, I wasn't a national coordinator alone. There was a whole team at the national where we oversighted the entire country. So every bit of information, as I said, hourly, of every crime that was reported, we would have gotten and did the analytics and the processing. So there isn't a case that took place in this country without me knowing or giving leadership, more specifically the civil unrest. So this specific case, when the timing was right over the periods, we had to package it as such. Today, I'm presenting a broad spectrum over different days of when the tweets came in.
Okay. Maybe let me make it easier. It's correct, isn't it, that you are not familiar with the specifics of this particular investigation?
My lord, I am.
You are? Okay, good. So you know that Colonel Nazo, for example, made inquiries from cellular phone companies?
My lord, the method, that's one of the methodologies that we would follow in doing the investigation.
No. Please listen to the question carefully. Do you know whether in this particular case, the investigating officer specifically required information from cellular companies? I know you are saying that's what would happen. Fine. Do you know whether it happened or not here?
My lord, I would have believed to Section 205 would have to be done in order to establish a number, but I cannot say specifically on this case that he did or did not.
So, just a moment, Major, to be specific. The question is whether you know. So your answer should be is either you know or you don't know. Do you know or you don't know? That is the question.
But Lord, I want to believe I know that Section 205 should be done on every investigation that we will busy with.
So the answer to whether you know that it occurred or you don't know, what is your answer?
I know, my Lord, the 205
You know.
would have been done.
No. Sir, please, can you just assist the court? You can't say, I know that the Section 205 would have been done. You know what I mean? The judge is asking you, his lordship is asking you, do you know whether it was done, not what, that it would have been done? Of course, it's like saying, if I say, do you know that the complainant was interviewed? Say, yeah, that would have happened because it's standard procedure in the police. That's not what I'm asking you. I'm asking you, do you know specifically in this case whether these investigations were done or not?
No, my Lord, then let me rephrase and say, I cannot say whether it was done in this specific case.
Yeah. So just so that there's no ambiguity, your question to your lordship's question, your answer to the question is now changing to no.
That's correct, my Lord.
Okay. Thank you. And do you know that the investigating officer also made inquiries with banks to trace the money trail of the accused to see if she was not involved in what we've now called the funding effort?
Just repeat the question.
Thank you, my lord. In the same vein, do you know or do you not know whether the investigating officer also, apart from investigating cell phone companies, investigated banks in order to ascertain whether the accused was involved in the funding of the unrest? Do you know, yes or no?
No, my Lord, I do not know whether it was done in this specific case.
Okay. Do you know that it was done in other cases?
Yes, in other cases where the normal methodology would have been requested, but in this specific case, I cannot say whether it was done.
Yeah. That would then mean that you don't know that the investigation into the bank statements of the accused before this court revealed that there was no such linkage between her and the so-called investigators. You don't know that?
No, I wouldn't have got you if I did not know. I do not know.
Do you know that do you know the basis of the state's case in this particular matter?
My Lord, I would just be brief. Yes, I do.
You do, okay. And you then agree with me that the basis of the state's case is that the accused was part of a common purpose.
Objection, my lord. There is no such basis that can be gleaned anywhere from the statute. The accused is charged simply in respect of comments she made on her Twitter. And the impact it had, and as I said earlier, whether it was a direct attempt to incite people or whether objectively seen it could be inciting people.
Yes.
Thank you, my lord. Maybe, my lord, yes, maybe let me rephrase the question. Do you know or do you not know that the investigating officer proceeded from the premise that the accused is involved in a common purpose or conspiracy with others?
Well, Lord, I would want to believe that I do believe it was. She was, in view of the number of Twitter other investigations, which I had insight to on a national level.
Okay, thank you. Well, that makes it easier. Then we don't have to refer it to the investigating officer. So you yourself, the basis of your evidence is that she was part of this broader conspiracy.
In terms of communication via Twitter, yes, my lord.
No. Please. Twitter obviously communicates to millions of people. That's not what I'm talking about. I'm talking as to whether it is your case that she was part of a conspiracy of instigators.
My lord, yes, via the social platform of Twitter. I categorically phrased the WhatsApp and the Twitter separately.
I see.
So on the Twitter platform, yes.
I see. So you gave the court, you said there were 8 groups of instigators or platforms, WhatsApp groups, correct?
That's correct, my lord.
So are you now saying that on top of that, there were also Twitter groups?
My lord, Twitter is individually based. Twitter is not groups. Twitter is on an individual. WhatsApp groups that has participants. On the Twitter account, it's the individual. You don't have multiple participants on a single Twitter group.
Yes.
You have followers. And
Correct.
I think when I categorically clear the difference between a supporter and a follower. So you have followers on a Twitter, but in WhatsApp you have participants.
Okay. So when you say she was in a common purpose or conspiracy, she was in a conspiracy with what? Followers?
Yes, my lord. The Twitter, 120,000 or some followers, that was the grouping to which would have responded to her comments and responded as followers.
Okay. So it was in a common purpose with followers. Is that your evidence?
That's correct, my lord.
All right. But as far as the WhatsApp groups are concerned, she was not a member of those.
Safely to say, yes, my lord, she was not part of the persons of interest in any of those groups.
She was not a member of any of the 8 Twitter groups, WhatsApp groups that you identified, correct?
That's correct, my lord.
She was not one of any of the 103 persons of interest that you identified.
On the WhatsApp, she was not, my lord.
She was not, right. So she was some lone wolf operating, unlike all the other people, she was just operating alone with 100,000 followers, correct?
No, my lord. She was the individual who posted, and other Twitter handlers and followers, they in turn disseminated to different levels. So as the accused before court individually would have sent out a message, but the followers would have followed up and sent it out. So our focus today is on the accused. What did she disseminate on her platform?
Sorry, General, maybe it's the way I asked the question. I'm saying, let's take somebody who was part of the Inc. group, right? She was not part of that. We've established now.
That's correct, my lord.
Yes. Now, that person would have been in touch with the people in their WhatsApp group, and as you say, they might say, go and fetch petrol, do this and the other. She was not involved in that.
She, on the WhatsApp, she was not involved, my lord.
Yes. And therefore, your only evidence is that, unlike all these other people who were involved in those things, she was operating on her own, apart from the fact that people would respond or follow or retweet and so on. But she was just on her own. She was a conspiracy of one.
My lord, I think to place it in perspective, and I mentioned the cyber forensic expert will come, but to answer the council's question, the participants on the WhatsApp group, to which she was not part of the WhatsApp group, some of those participants are her followers on a Twitter group. So I think that wasn't for me to testify. The cyber forensic will bring that clean. But now that you asked a question to show that there was people that's on this group where she was not, but they are followers on a Twitter group.
Okay.
So it would be wrong for me to say the accused before court was part of the WhatsApp. She was not. But participants of that group were indeed part of her followers.
I see. So being her follower is also what? A crime. I'm one of her followers on Twitter. Does that make me a conspirator?
No, my lord, I don't think it will make a person a conspirator.
Oh,
But if the person takes it further from the Twitter and announces it on the WhatsApp, and then as a council, ward councillor tells to the ground forces, do ABC, then that has a nexus of what was said and how it was conveyed by the follower onto the WhatsApp group. The accused did not do it, but the follower did it as a result of the incitement.
I see. So for that, we can't blame the accused, correct?
Yes, my lord, we cannot.
All right. Now, this whole case, I'm sorry, my lord.
Just to get clarity on, you're saying you cannot blame the accused for what her followers did on the WhatsApp. I want to capture it correct. Is that what you're saying?
My lord, the way the council put it, I understood it, and I'm saying, yes, the accused would have said it, but if the follower took it to the WhatsApp, I cannot honestly say that the accused must be blamed. The follower is the one who would have taken either the message or the incitement or whatever we call it. So I cannot say that she's responsible for the WhatsApp. No.
Absolutely. No, thank you.
Thank you. I wanted that clarity.
Thank you, my lord. Yes. No, that's important. We're on the same page here. In fact, to be honest with you, and I don't want to give you legal argument, but just as a senior policeman, you would agree that the accused, or anybody for that matter, is not responsible for what the followers may or may not do, or may not say, or how they react. Correct?
Now, I don't think that would be correct, my lord, to say that we cannot, especially with a person of the accused stature, a certain comment or a certain message will carry weight of either goodwill or incitement or inflammatory, and so it would be wrong to say we cannot say it. In the context of which it was said, is going to be important.
So, General, just answer the questions truthfully and don't rephrase my question, because now then you're answering your own question. My question is, generally speaking, if I tweet something down here and 20 people like it, others don't like it, that's not my responsibility. That's all I'm saying, correct?
My lord, I think it's safe to say, I might not agree to everything council says. So my disagreement must not be seen as though I'm in opposition. I must just state the fact. The fact that I only placed parts of a context, there might have been responses from the accused on those things. And that is why I'm saying those responses, the cyber forensic who did the actual analytics will be able to say, this is a message, this was a response from a follower, was a response from her given.
Okay.
And I think that's important for the court to come to that, for understanding that there has been issues of that nature.
Okay, again, to assist you, let me ask it differently so that maybe you can see that we're on the same side here. Your evidence as to the content, and we'll come to the content of the tweets that you referred to, would not be different if nobody responded, correct? You would still, if she said, go and kill 20,000 people, she can still be charged. It doesn't matter whether someone responded or not. That's what I mean by saying that the two are not related. Would you agree? Or would you say she must be acquitted if nobody responded?
No, my lord, I won't say to be acquitted, but if as a result of 20,000 that we find that there was 6 people murdered, so the nexus of a message did it result in the 6 murders, then there has to be some accountability. We cannot say a person cannot be held accountable.
I see. That's a nice word, nexus, yeah. So in this case, have you established any nexus between these messages and anything that happened on the ground?
My Lord, on the global investigation, I want to safely say yes.
Yeah, okay, please tell the court.
That part, I think the cyber, because it might be asked, can you produce or not? The cyber forensic expert who went in the in-depth investigation of the Twitter, who's going to testify before the court, will be able to outlay all those that I'm referring to, my Lord.
So,
Perhaps then, Major, if
sorry, madam.
General, if then you say somebody else will testify and there is not you, then you rather not commit yourself and say you know or you don't know. Unless if you are able to testify on that, you can't say you know something that somebody else will testify on.
My Lord, I respect that. I'm committed on the fact that I had access and visual of all the Twitters, and I only referred specific, but there is an expert who did a consolidation or investigation of that, and that's why it wasn't fair for me to bring that to the court because she's the expert on that, and I had access of the content of it, so probably I refer to that on hindsight, and when I'm referring to her as the person that's going to come, I take note, my Lord, and respect it.
Thank you, my lord. General, please, I want us to work together here. You understand what your lordship is saying to you? Because before I asked you this last question, I said to you, is there or is there not a nexus between something that the accused said, tweeted, whatever, and a particular crime? Murder is the example that you mentioned. And you said yes. That's the problem. If you said I don't know, that would be the end of it. But when you said yes, then it invites me to ask the next question. Then you say, no, some expert is going to tell us. Then, do you understand? So I'll ask you again. Do you, General Governor, know whether or not there is any nexus between what the accused did, said, tweeted, whatever, and a particular crime?
My Lord, I will still say yes.
Okay, which crime?
My Lord, it's clear that the MI2P, the burning, the destruction, and once again, your very next question, counsel, was, can you show it or prove it? And here, my Lord said, I cannot comment on that because there's somebody else. So for me, my response, yes, I see there is a nexus from the platform where I operated and know the contents of the Twitter information.
I see. So, and you're saying the whole unrest, July unrest, is causally connected, because that's what nexus means. It's causally connected to something she did.
Well, I can't say the whole unrest.
Well, then which?
There is specifics that where we can show in terms of a Twitter that's there. So I cannot say the whole unrest. That would be wrong.
Okay.
I cannot say that.
Not the whole unrest, some of the unrest?
There is links or nexus that which we can say where she played an influential
With
part of it.
some.
Yes.
Okay, I'm happy with that. However, small, big, or medium, the sum is which part? That's some of the unrest that can be attributed causally to her actions. Which? Because when you say some, you mean maybe 3 incidents, 20 incidents, I don't know, I'm not asking you that. But which?
My Lord, if you look at the one where I commented, where she commented, let's take the fight from outside. And immediately after that, the McDonald's, the Wheel, Value Logistics started to burn, looted and burnt. Now, those are specifics, if you're asking that sort of specifics.
I see. And before that tweet, nothing burnt.
Before the 8th, there was nothing. Before the incarceration on the night of the 7th.
All right. Okay, General. You see, that's why I wanted us to deal with specifics, not all these generalities. So So your evidence is now that the tweet that was given on the 8th of July is the one that caused the burning of a McDonald's.
My Lord, let me restate. I cannot say
Oh,
that. I'm saying as a result of outside, let's start working from outside. Then these events took place. But there is no link to say the accused said go burn McDonald's, go burn this and that. It's the ground forces on the WhatsApp that took instructions from the ward leaders or the councillors or the people that was controlling the WhatsApp groups.
yes. So the ground forces that burned that McDonald's took instructions from their WhatsApp group leaders, correct?
That's correct, my Lord.
Not from the accused.
Not from the accused.
Oh. And so when you say causally related or nexus, you really mean that she tweeted something and some WhatsApp group leader did something and then somebody bent a McDonald's. That's the chain of causation that you want the court to accept.
My Lord, I don't want to be able to say McDonald's, as you say. I'm not saying the accused gave instruction to burn McDonald's. I'm saying as a result of the comments, we saw the uprise of these crimes being taking place. For me, the nexus or the link is as a result of the tweet, there was an activation of the ground forces.
Okay, I can't say I understand what you're saying, but let's move on. So the tweet that caused all this trouble is the one on paragraph 27 of your statement, page 8, my lord. Just before you even go there, am I right that here you obviously haven't put all the tweets, you put the most important ones?
That's correct, my Lord.
Thanks. Okay, so one of the most important tweets is this one. Comrades, you have not failed President J.G. Zuma. My ANC has. But you will fail him if the fight for radical economic transformation stops. You will fail him if the fight for economic freedom stops. So our struggle continues from outside and we must intensify. This caused people to ban things.
My Lord, in my evidence, Chief, I mentioned this 3 times, that specific sentence. So our struggle continues from the outside and we must intensify. Now, we have to unpack what is outside and what is to intensify. You can only intensify something that's either started or on way. And when you look at the videos of a mall burning and to intensify, when you look at looting and to intensify, and as I indicated, outside is what we, myself as the head, believed that outside was referring to because our former president was inside and now we on the outside, we must intensify. So that was our understanding, and that's the reason why we attached importance to that tweet.
I see. So, but you don't have to speculate as to what it is that was going to be intensified. It says, if the fight for economic freedom or the fight for radical economic transformation stops. So we know, correct?
That's correct.
Yes. So the fight for economic freedom and radical economic transformation, what does it got to do with looting?
A lot of importance again, the timing of this message. Immediately the 7th, the former president at midnight went. On the 8th, when this has come out, and we know that this country burst into flames on the 8th, and the timing of the message, yes, economic radical transformation we know has been long in the process to which we respect and we must believe in that. But so our struggle continues from the outside and we must intensify. Now, the timing of that message must also take the importance, my lord.
Okay. So I see. So you believe in the fight for radical economic transformation yourself?
My Lord, I can safely say I'm one of the believers in that.
And you also believe in the fight for economic freedom, for sure?
No, for sure, I am.
Yes. And do you believe that it should be intensified?
Intensified. Yes, let's say yes,
Thank
but
you.
from the outside. So you will see the word outside. You're not saying outside.
Oh, I see.
You
So
will see the word outside.
outside,
Protocol.
according to you, outside was a differentiation between inside the prison and outside the prison.
That's correct, my
Yes.
Lord.
So do you think the fight for radical economic transformation and economic freedom should be intensified outside of prison?
In the timing of the civil unrest, yes, I'm saying the outside was to the ground forces. Outside and intensified.
No. Please, I'm asking you now. You, as a fellow believer in radical economic transformation, do you believe it should be intensified outside or in prison only?
No, my Lord, we cannot, I mean, our president went inside, so we cannot intensify it inside.
We can only intensify it?
Outside,
Thank
as
you.
you said.
And because you believe that that fight should be intensified, does that make you a criminal?
My Lord, actions resulting from that comments, and which we'll see have preceded that comments, action that resulting from that would definitely make it a criminal act if it was said in the environment or the circumstances under which it was said, and resulted in acts of criminality.
I see. Okay. General, it will, believe me, it will help us all if you listen to the question and then answer it, please. Don't try to think where I'm going or whatever, because that's going to waste a lot of time.
Now, my Lord, I don't think that's fair, my Lord. Allow me as a witness under oath to testify what I want. I'm not going to testify to what you want. I must respond to what you say. And my honest response, with due respect, it is my response, and I'm going to respect that.
Yes, I believe your counsel, that Gangai, if accused counsel understand, will object, I will also look to that. But I think what is clumsy here, the issue that perhaps is put against you is if somebody who is said to be fighting for radical economic transformation gets inside, then the quotation said outside it must continue because somebody now who has been doing this is outside. It's inside. That's where perhaps the confusion starts from. To say then what is crime here? Well, I don't think you are forced to interpret something that you may not interpret. But these are asked from you because you are testifying.
And it's
Yes,
in your
my Lord.
statement. Your
Yes, my
own
Lord. Yes, my statement under oath. I'm saying the reason why I'm testifying to that is because at the time of us doing the investigation, and today it would not change because I would have believed that that's what we interpreted from the outside and intensified, and the timing in which it was said resulted in certain action.
Okay. General, thank you. Let me assist you. I'm not fighting with you. You understand that? I'm not, really, believe me. The reason I made that comment is because you did not answer my question. That's all. And I wanted to ask you if you remember the question. I'll just repeat it. Okay? Since you, General Corporal Governor, believe in radical economic transformation and you think it should be intensified outside, that's all you have to evidence so far. Does that make you a criminal? Yes or no?
No, my Lord, it will not make me a criminal in believing on a principle.
Yes.
That's the principle we believe in. It would not make me a criminal.
Thank you. Right. And
Just a moment. Do you
Sir.
have a chair there? You want to sit, General?
No, thank you, my Lord.
Or you may sit if you.
No, I'm comfortable.
okay. Thank you. Okay, so yeah, now we're together. And the intensification, which we all need as a country, should be at all times, correct?
Yes, my lord, if we want to push an agenda, it must be continuous.
At all times.
Yes.
Thank you. So that intensification at all times, whether there's unrest or no unrest, we should not stop that fight, correct?
My lord, yes, we don't have to stop, but I think the crucial word that what the council is missing out, and I don't want, is the word outside. Intensify is there. Now, we know the incarceration on the 7th and then outside on the 8th is a clear indication, but council is outside and intensify the principle. I support intensify the principle even now. But at the timing, when the government made inside and she to intensify outside and intensify that clear. And I think also must be fair in using that word. I'm not saying agree to it, but both those words has to be part of one sentence in which she crafted a message.
Fine.
Sir, I apologize for interrupting. I have generally allowed my people to continue in that line of questioning because I thought we'd get somewhere sometime. The accused is not charged with conspiracy. The accused is not charged with causing anything. The accused is charged based on statements made. And the question that the court must determine at the end is, did were those statements insightful? They had potential to be insightful. And when we're dealing with the charge of incitement, one does not have to prove the commission of an offense. If I merely had to say now, for the sake of an example, let's go and kill the guy that's selling ice cream at the beach. I'm inciting. Nobody has to go and kill him. Nobody has to go and threaten him. The mere fact that I've said that, why don't you go to the beach and rob cars? I'm inciting. We haven't charged the accused. The accused is not being held. We're not going to need any evidence that she incited a particular event. The question is, the question that the court has to determine in the end is that the words that she used, one, was it meant to be inciting, Section 18, or did it have the potential to be insightful, objectively speaking? In other words, did someone who heard those words, someone who heard those words have come to the conclusion that it was being incited, or they were being incited? That is the two issues that we must decide. There is nothing, I can make 220 admissions now to say that the accused in this matter did not commit any offense directly, that she did not directly conspire with anyone to commit offense. We don't have that evidence. What we have evidence of is utterances made on Twitter, distributed to 124,000 people, and the court must decide whether those comments amount to an incitement. That is what the case is about. And now what we are doing is trying to move the goalposts and confuse the issue. There is no question of a conspiracy. There is no question of a common purpose. The question is what she said, the words that she uttered, the words that were distributed as stated in the Righteous Assembly Act. Did they incite people? Were they meant to incite people, or did it have the potential that somebody who received it could have felt that it was incitement? Those are the questions before the court.
Yes.
My lord, I don't know what's happening now. My learned friend is busy arguing the case. We'll do that at the end. I don't know what he's doing. Whether is it an object?
Wait,
Can I
just a
finish?
moment. Wait.
I apologize.
No, wait. Sit down. Once he's down,
I
you may reply. Thank you. Proceed.
Thank you, my lord. My lord, with the greatest respect, my learned friend, what he's doing is not correct. Because he's allowed, of course, as we all know, my lord, to object to a particular question. Then I respond. But he is not objecting to any question, he's just arguing the case. I don't know which question, if he's objecting to a question, which question, because all I did was to take the witness on his own statement. I don't know this story about conspiracies. We've moved a long time from conspiracies and common purpose. We are now at a point where the witness has said he has quoted the most important, insightful statements, and we are dealing with one of them. So I don't know what's wrong with that.
My Lord,
That is your last reply now on the issue.
thank you.
Yes.
My Lord, it is not a matter of arguing the case at this point. I will still argue this case, and there's a lot more that I need to argue. I have allowed my colleague some latitude in his cross-examination of this witness, because I thought we would get to a point. Now, to cross-examine this witness on conspiracy and common purpose, and it goes on, and I'm saying I'm now objecting to this line of questioning, because this line of questioning is irrelevant to the charges that they accuse face. Thanks, my Lord.
And I believe, let's just comment down a little bit. So we all know that the accused is not charged for a complete crime.
Indeed.
It's not charged for a complete crime of what is incitement.
It's charged for incitement.
So what Mr. Wolf is doing, it's questioning the accused on what the witness and what he has written in his statement as evidence to the crime that the accused is charged with. So far, if perhaps that was not relevant, it will not have been contained in the statement. That's how we look at it. But if he overstepped it, then you will be more than welcome. Surely there is no issue of common purpose. That one might be relevant. But the issue of incitement, how is this statement relevant to incitement? I think he's more than welcome to ask the author of the statement on that. You may proceed, Mr.
Yes, God, I'm indebted to the court. General, yes, we're not going to be long on this. You and I have established that you did not quote all the tweets. You just quoted the most important ones, correct?
That's correct, my Lord.
Yes. And one of the most important ones, the first one actually of the most important ones that you quoted is this one in paragraph 27, one we're dealing with now, correct?
Yes, that's quoted,
Yes.
and to which I'm not the author. The tweet itself is out of the Twitter.
No, when the Lordship says you are the author, it doesn't mean you are the author of the tweet. You are the author of this statement.
That's correct, my Lord.
Okay? Yeah.
Understood.
Understood, my Lord.
Thank you. So it's your own statement. You signed it before God. You said, please help, so help me God. Correct?
That's correct, my Lord.
Yes. That's what it means. Now, in this statement, you selected this particular tweet as evidence of the incitement, correct?
That's correct, my Lord.
Yes. So that's where we are. So I don't know how that can be not relevant. Now, I'm busy saying to you, okay, maybe let me assist so that we move on. I'm going to argue that your theory about this particular tweet is fanciful. There's nothing insightful, nothing violent, nothing to do with looting or anything in this tweet. It talks about the intensification of the radical economic transformation fight, which you agree with. And just so that you don't accuse me of leaving out the word outside, it talks about that fight being done outside. And according to you, said outside means outside of prison. I agree with that. And I'm saying that intensification of the fight outside of prison is not a criminal offense. Would you agree?
No, my Lord.
Okay, it is a criminal offense. The intensification of the
My
fight.
Lord, allow me to expatiate.
Yes, please.
Had this message been said on the 1st of January as a New Year's resolution and nothing happened, is different to something that was said on the 8th of July 2021 and something did happen. Now, I think we must just be, and with the biggest of respect, I think the importance or the timing of the message, the 1st of January and the 8th of July, and the resultant from both on the one, nothing happened. On the other, something did happen. And as the council correctly and the council for the state, I cannot say the accused before court has committed murder, burning, arson, looting, nothing. No specific crime.
Or terrorism, even worse. You can't say she committed that, correct?
I cannot say specific crime, my lord.
And you can't say somebody committed those things as a result of anything she did. We've already established that.
My lord, I think through my evidence today, it's safe to say we can't, but probably with the evidence that's to come, there might be a link and a nexus of evidence that's still to be laid.
Fine. Thank you. Normally, that is the point at which I should be saying I have no further questions, because we now agree that none of the things happened as a result. But let's just tie up a few things. Do you know, as the national coordinator, why it took 4 years to charge the accused?
My lord, I think if I can place with perspective that this investigation, as I said, it was an unprecedented type of crime and reasoning. And for the volumes of the cases that we were dealing with, and as I indicated earlier, part which the Lord said don't mention, there's been numerous arrests already made around the civil unrest, and this is one of the numerous ones. It's safe to say that the couching leg, we only started the couching leg of arrests in the last 3 months. So it's the timing, once again, the volume of work that had to go into the investigation, the different methodology that was used to ensure that we've got sufficient evidence or complete evidence to bring before court. The WhatsApp was very much easier platform. So I cannot say that, the 4 years is a too long period, because we still got others that have not even reached the stage of finalization. We still continue because of the volume of work.
Do you know or do you not know why it took 4 years to charge this particular accused? If you don't know, you don't know.
No, I do know, my lord.
Why?
It was because we have prioritized our investigation. We prioritize our investigation with the accused on the other side. Therefore, this is one of the cases that came after that. You will have seen the Brookside Mall, arrested, convicted, sentenced. Others are still continuing in court, and others are still pending investigation. So I would say to the court is that, to the Lordship, is that these cases were prioritized because of the volume of cases. So it received attention in this period.
Okay, let me ask it differently. Do you know that as far back as, 2021, it was already established that the accused had no financial chain related to the unrest? You know that?
I would have become aware that there was no link with the financial side.
Do you know that in 2021 it was already established that her cellular phone after the Section 205 was not linked to any of those 8 groups? It was known in 2021 already. Do you know that?
I'm very much aware she was not linked to the WhatsApp group.
Yes.
I said it.
So at that time, the state, or the police at least, not blaming the NPA at this stage, the police at least knew that she was not part of the groups. Her financial affairs were not linked to any funding of the unrest, and her cellular phone movements, I think you guys call it triangulation and so on, did not place her anywhere in any place that would link her to the unrest. That was known by the end of 2021, correct?
That's correct, my lord. It was known, and therefore it was not at that point in time more important than the one that we had, where we were able to link perpetrators and arrest them and charge them and take them. And that's the prioritization that I'm talking about. That at that point in time, 21, 22, probably up to the time she was charged,
Yes.
we prioritized our investigations.
Yes. So, no, that's fine, Chamber. So, am I right then to say, having ruled out all these things that would normally have linked her to the crime, the only thing that we are now left with is what we've just done, you and I, the interpretation of the tweets. Because we now know that you investigated the banking, you drew a blank. You investigated her involvement with the WhatsApps, you drew a blank. You investigated cell phone movement, you drew a blank. So the only thing that's left is the interpretation of the tweets, correct?
That's correct, Honorable Worship, and that would allude to your question. Why 4 years later? Because all those processes would have taken time to have done at some point, and probably 4 years later is why she is charged now.
So it took you 4 years to work out that the call for the fight of radical economic transformation causes the banning of a McDonald's.
Well, I think it's unfair to put it the way, Council, because here we had murders, here we had mass destruction, and here we got suspects of prima facie evidence. Now we cannot package that and prioritize something. We went according to the evidence and the availability of what was there. And we, as I said, the prioritization of the cases took precedence where we were able to link people. So the accused before court, and rightfully, 4 years sounds too long. But in context of what we were dealing with from an investigative and a head, I'm saying it's adequate because we still got cases that are probably only halfway or three-quarter way investigated. That's still going to probably take us another 4 years to put on the road.
Okay. Well, that's fine. It's correct, isn't it, that the genesis of this particular case was the complaint by the complainant, Ms. Trent, or you don't know?
I'm not aware of a trend.
You don't know Ms. Trent?
Trend, no.
You don't know the complainant in this case, who it is?
Is it, my Lord, forgive me, if you're talking about the lady from, I'm afraid to even mention his name because it might just, Paul O'Sullivan's office, yes, that was it. So I don't know, I think Mary and him. Yeah,
yes,
Mary, but
Mary
I
James.
Yeah, I don't know her surname, Trent. But
Okay,
it's the lady from Paul O'Sullivan's office, yes.
Okay. Do you know that the genesis of this matter is the complainant of the lady that you say is the lady from Paul O'Sullivan's office?
Yes, Mary, you mentioned the second name, not Trent before, it's Trent as well.
It's Sarah Jane is her first name. Trent is her surname. Trent.
No, that's the name, the first two I know.
Yes.
I didn't know the surname was Trent.
Okay. Yes. And you say she's from O'Sullivan's office.
Paul O'Sullivan's office, yes.
Yes. So do you know that is the genesis of this case?
Yes, the initiation.
Yes.
I would want to believe, my Lord.
And that without that complaint from Paul O'Sullivan's office or Ms. Trent, we wouldn't be here.
No, my Lord, I don't think that will be correct because when we did our intensification of persons of interest on the WhatsApp platform and the Twitter platform, the accused before court was definitely a person of interest on the Twitter platform, together with multiple other Twitter users, to which we have made arrest and still pending arrest on other cases.
I see. When did she stop being a person of interest? Because you've already testified that she was not one of the 3 persons of interest. But now you're telling us at some stage she was. When did she stop being a person of interest?
My Lord Counsel must not mislead the court. I said she was not one of the 103 persons on the WhatsApp platform. The
No.
WhatsApp platform is where the 103 people of interest, persons of interest, my affidavit is clear of the 103 people on the WhatsApp platform, and she was never on the WhatsApp platform. So on the Twitter platform, yes. So I think my affidavit, if I can refer, the court allow me.
General, I'll assist you go to page 3 of your statement. Paragraph 10. Are you there?
Yes, correct, my lord.
Your investigations that you've done for the past 4 years or so have come up with 103 persons of interest, correct?
Yes,
Those people are listed on column 1, 2, 3, 4 of your table, correct?
that's correct, my lord.
Of those 103, none of them is the accused here, correct?
That's correct, my lord.
Yes. That was, I thought maybe I misunderstood. That was you and I were agreed on that.
No, my lord, you're not, the council is not. If you look at paragraph 13 and read paragraph 13 in context, where it says that resulted in us identifying 103 persons of interest attached to the specific 4 grouping on WhatsApp. I
Yes.
think that is correct. That 103 to WhatsApp. The accused is not attached to WhatsApp. So it's wrong for the council to say that under oath, I said this paragraph 14 is clear. I think my English is quite clear on that the 103 is to the WhatsApp and not the Twitter.
No, General, it's not English, it's arithmetic. I said she's not one of the 103 persons of interest. Do you agree on that?
On the WhatsApp, yes, she's not, my lord.
Yes. Okay. Now, the question I'm asking you is, are you denying that what sparked or triggered the interest or investigation into her was the complaint from the lady from Mr. O'Sullivan's outfit, company, office? That's what it is. You deny that?
Can you simply underline what?
Are you denying or admitting that what triggered her being a person of interest up to the stage we're sitting here now was the complaint from Mr. O'Sullivan's office?
My lord, that was not a trigger for our investigation.
Right. So then you would disagree with Colonel Nazo. Sorry, my lord, if I may just. If Colonel Lazo is to say that he received a complaint from that lady, which put out the incitement, and that as a result of that, or from the outgoing, and with the statement from the complainant, he became of the view that she conspired with others and so on. For you, that was not the trigger.
No, my lord, Colonel Nazo is perfectly in order. Remember, he is investigating a specific investigation.
Yes, that's what.
Me, as the national coordinator, and to which Colonel Nazo did not have information at the national level, to which from the day it started, preceded and going forward, I had information. So Colonel Nazo's affidavit is 100% in order. He's talking in relevance of this specific investigation. The question is, was the accused at court a person of interest to us at the national level before this case? Yes.
What do you mean before this case?
Before the registration or the complaint of this lady, Sarah Jane. So,
when was this complaint registered in your view?
well, Lord, it was long after we started there, after the 8th, between the 8th and the 15th. We already, the person of interest, the accused was a person of interest already by then with us. So this James lady's statement or whatever request came after that. The question you asked, was she a person of interest? To me, yes. The Nazareth would not have known that because they did not operate on the national level.
Do you remember the question? When, in your estimation, was Ms. Trent's complaint registered?
Lord, the council just asked that. I cannot remember the date.
You don't know?
I do not know that.
That's fine.
But was she a person of interest at the time at national level from the 8th or before the 8th? Yes.
You know,
Just a
General,
moment, so that
I'm sorry, my lord.
we are all on the same page. Mr. General, I was saying that, for clarity, I was saying that the accused before court was a person of interest to you before the 8th of July 2020. Is that what it is?
8th of July 2021. Yes, my lord.
So before that, she was
A person of interest. Yes, my lord.
I wanted that clarity.
Yes, thank you. And that was based on what? Tweets?
On tweets that was made on the 29th, on the 30th, the day after the Constitutional Court judgment that was made. So our interest for her as a person of interest emanates before this affidavit or request from
I
Sarah
see.
Jane.
How does one qualify to be a person of interest? They must incite violence, correct?
No, my lord. In this specific case, we talk about incitement. But for us, from a national security perspective, intelligence gathering, we don't have to wait for the crime or the person. We have people of interest. Remember, the case of our former president has taken, it became well known. So there has been intelligence gathering at a high level. We have to monitor the temperature of the country. And as a result of every court case, as a result of engagement, we did due diligence by doing the necessary intelligence gathering.
And now please answer the question. How does one become a person of interest? Do you have to just be a person who comments on former president's cases? Or does it have to have a link to potential crime?
My lord, it has an influence on the country.
Also, as long as you say something that has an influence on the country, you are a person of
It's
interest.
one of the aspects in the arena in which the accused before court operated. She's an affluent politician. We know she's coming from that. And the aura around her did not orientate around cash in transit or murders or robberies. Hers was around the country, the political environment. And it's important that we, as a security cluster, noted, and we, even up to now, we still have that overarching aura of the current political environment.
So basically, you are saying the police have been spying on the accused before and after the unrest. For what?
A lot of this council's words, spying.
Okay,
I
intelligence. Let's call it intelligence. So you've been having a focus on her even before the unrest started, correct?
My lord, that is the normal strategy for any security agent or cluster that we have. We have overview on a lot of people, whether it's accused or people sitting in the court. There is intelligence level of getting information.
No, I understand, General. So basically then, she was a person of interest in general on whatever you're saying, nothing to do with the unrest, because the unrest had not happened yet.
Yes, prior to the unrest, she was a person of interest. After the unrest, she still continued to be a person of interest.
Yes. No, let's work together here. So she was a person of interest for things that are unrelated to this case. Because the things that happen, that have to do with this case only started on the 8th, according to you. But she was already a person of interest, correct?
No, my lord. I'm not understanding the council where you said, and I'm saying again, the civil unrest emanated from the 8th onwards,
Yes.
to which she was a person of interest. I quoted two places on the 30th before that, where she was also, but she has been a person of interest to us before the civil unrest.
Yes, that's all. I don't know why you're giving that long answer. It's just a yes or no. The accused person was a person of interest long before the unrest, correct?
That's correct, my lord.
Thank you.
I believe court order, it's your responsibility to ensure that there is order in court. We welcome public in court, but provided they behave.
I appreciate a lot. All right, no, that's, thank you so much, Chandra. And you were saying it's continuing even now. She's still a person of interest.
Let me reserve my comments, my lord, because that is a continuity. Because then I'll be saying, can you prove what's next? So I reserve my comments not to answer that.
No, that's an answer on its own. Okay. This is what I was coming to, General. You accept that.
Just a moment, Council. I'm reminded now it's 1 o'clock.
It is, my lord. If your lordship can just allow me one question, so that
Yes,
I'll start on this. You accept that it would be wrong for the police, for the state, the police, the NPA, and everyone else, to just act on the say-so of Mr. Paul O'Sullivan's people, and for whatever motive, whether they have a political motive or whatever, but on the say-so of outsiders who come and say, I think so-and-so is guilty of X, Y, Z, and even specify the sections and all that, and that the state simply becomes a conduit for that. You accept that that would be wrong?
Yes, my lord, we do not act in that way, that somebody just gossip or got an opinion and the police will react. We will further verify the veracity of that. Do we have prima facie evidence? Is there circumstantial evidence? Is there sufficient evidence to come to court? And I think that's the call with NPA, what brings us here. So just on the mere opinion of somebody, that doesn't suffice to say that we can come to court or charge somebody.
Yes, and therefore it would be wrong, I suppose that's your answer, for the states then to act as a result of pressure from political syndicates or criminal syndicates, you know, the kinds of things we're dealing with in the country right now, correct?
But it would be correct to follow up on the submission and to verify, and then once sufficient, yes, but haphazardly, I don't think it's right. As counsel says, it's right. You just don't haphazardly take something and run and say we're charging you.
Thank you. Let's go, please. My lord,
Thank you.
got to be a compliment. I'm indebted to you.
We will break for lunch. We'll come back at 2 o'clock. Court of Unrest.
I don't feel that you second my thing.
Oh, okay, yeah.
How many degrees removed? Take your notes. How many degrees removed Duduzile take you up? Five. How many degrees of separation? 5 degrees.
Can you please switch off office, set one for the manufacturing because the interview is recorded.
Mr. Kanga, I wait your witness.
I'm just as surprised as everybody else. Lord, can I just step out to find you? I know you went out, but I don't know where he's gone. Can you go to
We send you to
Yes. My Lord, I don't have juniors. These are my equals.
Unfortunately,
I have no juniors. They're all at the same level as I am.
Oh, I see.
Yes, my lord. My apologies. I was waiting
So
outside.
it's understood, Mr. Kanga. It's the law for my proceed.
as God pleases, my Lord. Good
I'm sorry, you
afternoon,
are not Mr. You are Major General.
Major General.
No problem, sir.
May proceed.
Thank you. Yes, good afternoon, Major General. I hope you had a good lunch.
No, thank you. Did.
You did. All right. Thank you very much. We are going to just resume where we were. Just to remind you, remember we were at the point at which I was putting to you that the genesis of this was the lady from Paul O'Sullivan's office. And you said no, by the time she came, it was long after the police had an interest in this accused, correct?
Yes, my lord. She came after when we already had the person of interest. She came after.
Yes. But the point I was making was that she's the one who instigated the chain of events that led us to be here.
My lord, I must agree that for this specific investigation, hers would have been part of this current investigation. Like I said, I must separate the different investigation, but this investigation, I would believe her request or her letter or whatever it is
Sparked it.
would have caused this investigation.
Thank you. Okay. Well, then at least we agree on something. Now, and just for your assistance, the reason why I say that is because, unlike what you were saying, and I'm sure maybe you had a look over lunch here, her statement was deposed to on the 13th of July. And the first statement from Colonel Nazo was on the 15th. So that was the chain. But we've already agreed that that's how it panned out, correct?
I just want to correct the perspective. I never saw it. I don't have access to any of the statements in the docket, so I did not see anything in lunch
Okay.
or during
No,
lunch.
whatever it is, maybe it was the lunch that brought back the memory. That's fine. No, I'm not suggesting you did something wrong. I'm just saying that at least I'm glad that you've changed the statement that she came long after, because that was not correct. But I'm not quibbling with that because you've corrected it. Okay, fine. Then let's move to something else. And you've already answered my next question that followed from that, was that it is improper for the police to simply mimic somebody's, we don't know what her motive is. It might have been political, but she's going to come here, she'll answer for herself. But you've already answered that as well, correct?
Correct, my lord. I did indicate that we won't just haphazardly take out. We'll give veracity to the information that comes through.
Yes. Fine. Now, I just want to clarify something. See, as an officer of the court, I have to have a duty not to ask a question that is misleading. I asked a question earlier which might have been misleading, so I want to correct that. Remember, I said, I put to you that the statement on paragraph 27 was the first one that you cited. You remember me saying that to you?
Yes.
Yes, no, that wasn't correct, my lord. The statement that you quoted first is paragraph 24. It's the one that says, "Makabane isikhathi sokulwa kule nkundla ngomakhalekhukhwini siphelile amandla."
That's correct, my lord.
Thanks. Okay, just so that we clarify that now. Okay, now let's go there, because you've said these are the most insightful or the most important statements. Would you agree that statement, that first statement also has nothing to do with violence.
My Lord, I think just to
It's in paragraph 24.
yes, paragraph 24. I think just to put in perspective, I should have just responded. This is the indication of your earlier question. Was she a person of interest after the 8th or before? This is an indication of a person of interest before the 8th. That
No.
this comment took place on the 30th of June is to what you're referring to. But I'm just saying, your question now is, has this got to do with violence? Now, once again, my Lord, the timing of the message is clear that this message would not have any influence on the civil unrest that started on the 8th. But as a person of interest, where we refer to as a result of the Constitutional Court's finding, we had to monitor the temperature, we use the word temperature, of the country. And this is one of the immediate responses to the Constitutional Court's finding on the 29th.
No. I think you are confusing yourself, but that's fine. The
Before you
Thank you, Madam.
I need clarity. You say, yes, the statement is here, but it has nothing to do with the violence that started on the 8th. I want clarity on that. Is that what you are saying?
My Lord, Counsel asked, does this statement refer to violence? So I'm saying the timing of this message on the 30th has absolutely nothing to do with violence.
Yes.
It has nothing to do with violence.
Okay, let me just, and again, I'm not fighting with you, but just a word of advice. Please answer the question. If you want to explain, that's fine. The court will allow you, but answer the question. Does this statement have anything to do with violence? Yes or no? And then if you want to explain, you can explain.
No, my Lord, it does not have anything to do with
Thank you.
violence per se.
Okay, thank you very much. All right. And then your further explanation is that, but because of when it was issued. Otherwise, it would have nothing to do with violence, but you're saying you are throwing some inferences because of the time at which it was issued. Am I right?
My Lord, yes, it's a build-up to that, but violence, no.
No violence. Okay, good. And that statement is, as I said, that one is really the first statement. In other words, in your listing of the most dangerous statements, that is your number one.
This is the initiation of what we picked up.
Yes. Just answer the question. In your listing of what you've referred to as the most insightful and dangerous statements, this is your number one.
No, my Lord.
What number is it?
I did not categorize what's most dangerous, what I refer to specifics that led us. I tried to show before the civil unrest on the 8th that there was communication, and after. So I cannot say that this is the most violent or the most dangerous one, as the counsel has put it. This is one of the many, and that is why I said I'm taking the words of the Lordship that I mustn't comment on a witness that's still got to come testify. She might come testify about 30 other quotes.
That's fine, Mr. Major General. But remember, in the morning I said you only cited the most dangerous and insightful statements, and you said yes.
Yes, my Lord. I
Yes.
did say yes to show the court that it wasn't only after the 8th. There was a build-up before and after. I just tried to show the pattern
Yeah.
that for a person of interest never came on the 8th. This person of interest was before the 8th as well.
Okay. All right. Let me. I'll play it your way then. Okay. Of these statements that you've quoted there here, then which one is the most dangerous? You have three categories. You have got this one we've just dealt with. You've got the one we dealt with earlier before lunch, and then you have the We See You series. Let's call it that. Which one of those three is the most dangerous?
My Lord, I don't think I want to answer it in the way which is most serious. What I will answer and say, the one of that's referred to in paragraph 27, the immediate response after the incarceration, for me was a turning point or a breaking point. So I see that as very important. I don't know what's dangerous about that, Council, but for me, it was an important point for us to decide and see immediately after the incarceration. So the struggle continued from outside and would intensify. So for me, I see that as an important point in the timing of the message. Then the third one you refer in ICU or VCU is also equally important, because when photos and video that was released of burning and looting and VCU and ICU, literally it has one meaning, but in the environment of what was taking place, that cannot be interpreted literally. But I'm saying, for me, the one on 27, I would regard it as an important point for me. Dangerous, I don't subscribe to that word, Council.
No, it's not me, Minister, it's you. I asked you before lunch, did you pick out the most dangerous and insightful statement? You said yes. Do you remember that?
My Lordship, dangerous was your word, not my word. I just answered to
No,
your...
but when you say yes, then it's your word. Because otherwise, when you agree with me, if I say, is it Monday today? You say yes, then we're both agreeing that it's Monday.
No, Worship, the Namas withdraw, because I never agreed to dangerous. I thought it was council word of using that, not English, but that word is not my word. I never used, I say it's important, not dangerous.
Okay, fine. Your word, important is
That's
your word.
right. That's correct, my Lord.
Okay.
Lord,
Let's use your words, not mine. Which, in the context of this case here, of this statement, is the most important?
my Lord, I would say the one on paragraph 27 and the one on 28, in the context of when it was made and disseminated.
Okay, so number one is the one about radical economic transformation we dealt with in the morning.
That's correct, my Lord.
Number two is we see you. That's on paragraph 28.
That's correct, my Lord.
And then number three is isikhathi sokulonga inkundla yamakhalekhukhwini siphelile.
That's on paragraph on the 30th.
24, paragraph 24.
Yes.
Okay, fine, good. So let's deal with them in that sequence then. We've dealt with number one before lunch. So let's go to number two, which is paragraph 28. What is, quote unquote, important, dangerous, whatever the word is, about a tweet that says, we see you, after mentioning the location where a video was recorded?
My Lord, this tweet, like, I just want to place on record where I said somebody else will come, but I'm not saying that person. I'm going to say the tweet emanated from a burning of a premises where the video and photos was trending, buildings was trending, and the accused before court shared that on a Twitter and said, I see you, or we see you.
Yes.
Now, it became clear, a person of influence, a person of authority, we know at that point in time, she was an influential person in the political arena. We know that she is the daughter of the ex-former president.
Mm-hmm.
And as a result of the incarceration, this took place on the 9th and 10th. There was many tweets, as I said, 19 tweets, but which one of the 19, obviously I don't have that with me right now, but those words was attached to a scenario that took place already, that went out, I see you. It's similar to saying, because I'm going to use a very naive, my Lordship, is that if there was a stabbing, congratulations, because let's say enemy was stabbed, congratulations. The word congratulation on its own is one thing, but in the context of which it was said, will, as though you're encouraging or appreciating the stabbing. The very same thing over here, we see you or I see you, to the burning, is a clear indication of her support to what has taken place. It's a view that everybody must know that she has the support or the blessing. But that's the way it was said. It was said in that context, not as a standalone I see you or we see you. it was attached to a specific item.
Okay, I can't claim that I understand. Let me ask you in short questions. You admit that that was done in relation to something that had already happened.
That's correct, my lord.
Okay. You also admit that it was done in relation to videos that were already trending.
That's correct, my lord.
Right. And then comes the long explanation. So you say, and you also admit that if somebody else who's not the daughter of the former president or a person of interest had said this would not be important, correct?
No, that's not correct, my lord.
Okay, if someone else who's not the daughter of the former president, not a person of interest, had merely tweeted, "We see you," with that video, would they be sitting here now?
My lord, definitely, if you look at that specific "we see you" or "I see you" alone, stand alone as the only tweet, nobody will be sitting here. But where there's a build-up of tweets, as I said, it's 19. This could have been number 19 itself. There's a build-up of tweets, and we got to look in the context of that. To stand here and say this alone would not put anybody here, it will be wrong on me. I'm saying the reason why somebody is here is as a result of preceding tweets as well.
Okay. So if someone who's not the daughter of the president or a person of interest had tweeted, "We see you" 19 times, they would be sitting here.
My lord, we see it, it's already people are appearing in court who is not the daughter or son of the president. Ordinary civilians, they are sitting in court because of same and similar communication on Twitter.
I see. So there's someone else in the country who's sitting in court because they tweeted, "We see you."
No, not these exact words,
No, well-
but use the Twitter as a platform for taking, but not these words here.
Yes, but please, Major General, we're talking about this particular accused. When I say to you, I'm trying to demonstrate, as you can see, how absurd or strange, maybe to use a neutral word. And you said, no, but there are many other people. So when you say that the court must now believe that she's not being singled out, there are many other people in the same position. And I'm asking you, is there any other person in this country, South Africa, who's sitting in the dock because they said, "We see you" 19 times, 100 times, 200 times, whatever? Is there such a person?
No, my lord, no, not
Thank
because of the use of this specific
Yes.
words.
Thank you very much. So from that, we can conclude the following from this evidence you've just given now. The accused is sitting here because she tweeted, "We see you" more than once. She did so in relation to videos of something that had already happened. And she's a person of interest and the daughter of the former president. That's the collection of factors that made her to be sitting here, correct?
Well, if that's the council's opinion, I want to say his opinion is that. But what is not correct, and I think I must just clarify that I did not say what you are saying, that these words are appearing on multiple tweets. I'm saying there are preceding tweets to this tweet that would have given rise, not as you said that the same word "I see you," "we see you" is used in 19 tweets. No. It's a build-up of the tweets I mentioned that would have given us reason to say that the context in which what was said has an influence or incitement side of it.
Which other tweets read with this "We see you" caused us to be sitting here?
My lord, as I indicated in my paragraph 28, that the accused published 19 tweets containing videos showing widespread looting. So I never referred to the 19 individually. I referred to a specific one which would have given credence for us to say that use of these words had an influence or insightful meaning in the context or the environment of what the looting was taking place. And if I may add, my lord, between the 8th and the 15th I referred, but the 9th and 10th, we saw the absolute disaster of South Africa crumbling in, when the majority of the murders and the burning and the looting took place in that first 72 hours.
Okay, just so that you don't get the wrong impression. Everybody accepts, myself and my client, accept that there was widespread violence. Okay? Are you happy with that?
Yes, my lord.
Everybody accepts that it was abhorrent and many people lost their lives.
Yes, my
Okay?
lord.
Everybody accepts that that should never have happened. Okay?
Yes, my lord.
The only business that brings us here today is not all that. That is bad, and history will show that it's bad. The only thing that brings us here today is whether this accused person, Ms. Sambudla Zuma, is guilty of inciting all those bad things or not. You understand?
That's correct, my lord.
Okay, so let's just be clear on that. Nobody is belittling what happened and how bad it was. Okay. Now I'm asking you again for the last time. You say at your paragraph 28, the accused published 19 tweets containing videos showing the widespread looting, protest action, and destruction in KwaZulu-Natal and Gauteng. In most of these tweets, she states as follows: "I see you," or "we see you," after mentioning the location where the video was recorded. It's very simple. So the majority of those 19 tweets were with "we see you" or "I see you," correct?
Yes,
Yes.
more than one tweet had that, my lordship.
No. Most of these tweets doesn't mean more than one tweet. It means the majority of those tweets. Am I right?
That's correct according to my affidavit, my lord.
Yes, thank you. Now I'm saying, if we then accept that the majority of those troubling tweets had these words, "we see you" and "I see you," I go back to my question: what in that incites violence?
My lord, once again, take out these 5 words and look at it. You see a picture burning or a murdered deceased on the floor. That's a picture. But add the words in the environment of this unprecedented uprising. It adds value from a person of influence. Had it been of an ordinary layperson with no disrespect to an influential somebody in the environment. So the tweet must be read just not as we do it today, "I see you, we see you." What was attached to it will have an influence or an inference to why we are here today.
Yes. Okay. I was going to ask you another question, but you've just said something very serious. So you're saying the accused, one of those tweets had a murdered person?
No, I'm just referring, as I say, if it's a burning building or a deceased, there's no murder deceased shown
So
on
why
that.
did you say that?
I'm just giving an indication to look at the pics. If you look at a burning building or a deceased and attachments, so the words will influence what's on the pic. Because now we're only looking at words. We're not referring to the actual pics of itself. If I got to withdraw deceased, let me withdraw deceased, burning buildings and looting.
Okay. No, I was just worried about that. And maybe you can explain to the court, when you say something is trending, you mean thousands and thousands of people are posting it, correct?
That's correct, my lord.
Yes. So what she posted was already trending. In other words, everyone else was doing it before she did it, correct?
The pic
Yes.
was trending, yes.
Yes, that's what I'm saying. Yeah. The only difference is that in the pic she put "we see you," but the picture itself was already trending, correct?
Yes, it was. The picture was trending. Her words was the individual chat
Yeah.
posted.
And so those thousands and thousands of people who posted that same picture, have you said they should be charged?
No, my lord, there was no need to charge something purely on a pic.
I see. I see. So what's the...
What was
Sorry.
his reply to that?
He said,
My
he
lord,
said-
The question was, were those other people involved in the trending of these pictures charged. What was your answer?
My Lord, the way I understood the council saying, those the pics were trending, and if those pics were trending, are those people being charged? And I said, no, there's no need to charge. That's only the pics that was trending. But the attachment of the tweet gave credence to the pic itself, because it's clear that when the trend is not the original person, one person would have posted, and then that photo would have been posted by multiple people as trending. So
For clarity, you said there was no need to charge those people. Reason being,
they only shared a pic, my Lord, on a social platform of Brookside Mall burning with flames.
yeah, this one, the problem was with the word I see, we will see.
That's right. As a result, there was words attached to it.
Thank you, ma'am.
Thank you very much. Yeah. And you're sure about this? If we go back to that information, we'll find that all these other people just posted a picture without words. Is that your evidence?
No, my Lord.
But that's what you just said.
No, that's what counsel is insinuating. That's
Okay, what
the
are
different
you?
tweets. In this specific one of the accused, there was a pic with the words.
Yes.
In some, there was pics on whether the same on the WhatsApp group or the Twitter. Let me stick to the Twitter because we're dealing with that.
Yes.
That the Twitter group, same. There's other tweets with the same picture alone. It becomes a fashion as a Twitter handle. You share it because somebody sent it to you. But when you attach something to it, then it becomes the individual handler's submission, a pic and then a wording under.
Okay. So if I had posted that picture with the words free Jacob Zuma, that would be incitement.
My Lord, I would say no.
Okay. But if I put it with the words we see you, it would be incitement.
Given the preceding tweets.
Which are what?
My Lord, that's what I'm saying. The 19 tweets must be taken in the context. Today, I only referred to the one to show that there was indeed communication by the accused on the Twitter platform. So,
Major General, I'm so sorry. We're just now moving around the same circle. We've established, haven't we, that the majority of those 19 tweets had the words we see you. Right?
that's according to my affidavit, yes?
That's according to your affidavit, then it must be true. Correct?
That's correct.
Yes. So let's be generous and say the majority of 19 tweets is 9. Actually, it's 10. Okay? Are you with me? Yes.
I'll agree to that.
Yes. So please tell the court, apart from this repetitive, we see you 10 times minimum, what was contained in the other 9 tweets that makes you to give this answer that you're giving, that it's only dangerous if it's seen with the other tweets. So let's forget the 10 that say we see you. What was contained in the remainder that made you that made them dangerous or quote unquote important?
Important. My Lord, with our investigation and the methodology, we were in possession of a global picture of all the tweets, of all the submissions, of all the trending, of the modules that was being used by the different platforms. And from there, we made it, we had to look at what is it that would lead us to evidence? What would have caused people to have reacted? And it's safe to say, as a result of some of, not might be the accused, but other tweets as well, and probably some of the accused, further looting has taken place. Now the question is that I never unpacked in my affidavit the entire 19, because I know there is an expert who's going to come and unpack it. So it was no need for me to unpack it. Mine was just to bring to the court's attention that indeed there was communication from the accused before court, before, during, and after. And I think the counsel is trying to find out, alone, I must agree, alone ICU and VCU would not have brought her to the court.
Thank you.
But as a result of the tweets preceding, it did bring it to court right now.
What did they say?
I think the pics and pictures was denoting certain things. Just that I cannot remember, but this specific one, I'm aware of the fire, the picture that you put, and what was noted under.
Yeah, no, there's nothing wrong. If you cannot remember, that's a good answer. So you don't know what the remainder of the tweets which made this statement dangerous were saying. You can't remember.
No, I cannot remember what the important part.
Thank you. Well, I can tell you for free that I don't know how many experts may come, but nothing more quote unquote important or dangerous was said in those tweets more than what you have quoted here. What do you have to comment?
My Lord, if that's Council's opinion, I think let the experts come and present to court.
Fair enough. Right. Now, sorry, my Lord, just looking for my notes. Where's my yellow page? Yeah. Sorry, I'm sorry, my Lord. Then, just to clarify something, when I said that the accused was not one of the listed quote-unquote persons of interest, you said the persons of interest only related to WhatsApp.
In reference to paragraph page 3. Yes, to
paragraph
those.
10.
Paragraph 10. That's correct, my Lord.
Yes. And what is metadata?
What is?
Metadata. The word you used at paragraph 10. You said the following WhatsApp chat groups were identified and metadata revealed the following.
Is what we, from WhatsApp, where we were able to recover from cell phones that were seized, from WhatsApp groups, we were able to get the communication, who sent it, what metadata is the communication, who sent it, when it was sent, the timing, when you go on your WhatsApp, it's information, and the information tell you date, time sent, who read it, what time it was. So that is metadata, my Lord.
That includes metadata from Twitter, correct?
No. This was only with WhatsApp.
No, Twitter was not involved at all.
Not on this chat groups. This was only done with the WhatsApp group.
I see. So when you said paragraph 9, that's on page 2, through the use of conventional and unconventional methodology, I'm reading from the middle, Malo, we managed to identify the following national groupings that were using social media platforms such as WhatsApp, Twitter, Telegram, and IMO. Must we read that to only refer to WhatsApp?
No, my Lord. I think you must, my Lordship, Council must just be fair. And it says, through the use of conventional and unconventional methodology, we managed to identify the following national and provincial groupings that was using the social media platform, such as WhatsApp, Telegram, Twitter, and IMO.
Yes.
So the references, the different,
more.
no, allow me, Council, that the platform that was used, I'm placing in perspective the different platforms, WhatsApp, Twitter, Telegram, and IMO.
Right.
So nowhere does it says over here, the metadata that I refer on to 10, paragraph 10, was in respect of the WhatsApp.
No, that's not what I said, sir. You see, that's why I said, just listen to the question. Don't worry about where it's going. Just answer the question truthfully. I'm saying, forget about paragraph 10 for now. On paragraph 9, when you say national and provincial groupings, you mean those that were on WhatsApp, Twitter, Telegram, and IMO, correct?
That's correct, my Lord.
Yes. That's all.
But does it refer to metadata in paragraph 9?
No.
No, my Lordship.
Sir, please just answer the question. Don't argue with me.
Just a moment.
Don't argue with me, please.
I think, Major General, first part of this question is whether what you say in paragraph 9, those groups, you say they relate
to WhatsApp, Twitter, Telegram, and emo, whatever emo is. I
perhaps
don't
you
know.
can just respond to the first part, then if there's need to continue, then we proceed.
No, thank you, my lord. My lord, I think it's important that I must place myself in perspective. I'm under oath in this court, and to be reminded 17 times now that I must be truthful, I think that is disrespectful. I'm under oath, and I stand here before the court to testify under oath. So I think I must also be able to say, because it's as though I'm lying. There's nothing for me. If I'm lying, then I'm under oath.
Major General, I can assure you, I haven't made a finding whether that you are not truthful. That process, it's far away from now. So if counsel have said that, have you said it?
I've never said he was lying. Man.
No, he said being truthful. I must just be truthful, and then I must keep on saying. I think for me, I'm saying, I got to respond to you. I will respond to you, not in agreement all the time with you, but I'll respond.
Thank you.
I believe that that's a truthful response.
That's fine. Thank you very much.
Thank you, may proceed.
Thank you. Let's go back to the question.
My lord,
When I say, okay, I'm sorry, Major General, I just want to make you at ease here. It's important that we do this productively and in a
Yes.
relaxed atmosphere.
thank you, Counsel.
So when I say to you, forget about paragraph 10, do you understand what that means?